Hi, everyone. Welcome to lecture video chapter notes for Chapter 3, Constitutional Protections. As I mentioned briefly in my little intro video, this one and technically a little bit of next one is going to be the last of the let's review things that you need to know about criminal law. Obviously, the first half is a lot of, we talked about it in intro, but at a basic level. So we've dug in a little deeper on this end. And then after that is going to be the nitty gritty, deep points. But there is some things to talk about here, and we are going to talk about it. But we're going to just kind of go over everything. Like I said, Chapter 3 is all about the Constitution, and if you remember from Intro to Criminal Justice, or if you've not taken it, one thing that is very important to note is that the Constitution of the United States of America, that is the highest legal code document for us. All of our laws have to be reflected back to the Constitution. It cannot be unconstitutional, which means that it's against the Constitution. So it's important. Everything has to be backed by our Constitution, which includes the Bill of Rights, and it includes all of our amendments that we've made over the years. Just a reminder that, it's been a while since we've made an amendment, but this is how it's all played in. So the other thing to remind ourselves and note is that while there is a United States Constitution, and that's the big heavy one, technically there are state constitutions. It's their own smaller version, like the state level charter where, if you are a resident of Pennsylvania, you are offered these rights and these privileges, and it's different than New York and it's different than Ohio, but technically they all are connected back to the main federal level. So that's what's important to remember as the broadest points, is that the Constitution is the key document. It is the first layer of, is it allowed to be a law? And we're going to talk about why that's an issue in this chapter as we go through. And so really the focus of Chapter 3, and the book even says their focus is more focused on like a key particular point rather than a broad overview of a lot of things, because it's not their focus. So what we're going to be talking about in particular is what kind of constitutional protections, as you can see here, the constitutional protections that are provided to an individual, any citizen of the United States of America. And we're also going to be talking about what rights are under that. And this is where things get interesting. And currently, not that it's super relevant to you, but I'm also teaching an Intro to Criminal Justice class right now. And those students, they're just got done talking about the basics of the Constitution, and they already got into a big discussion on what was covered. So anyway, when we talk about the constitutional protections, there are generally two types of protections that the Constitution offers. The first is that a defendant, if you are an individual who is getting charged with some kind of crime, you can challenge the constitutionality of a criminal statute or ordinance, which ordinances fall under the same thing as statute when we talk about it. So the book will, for this point on, say statute. I'll kind of go back and forth to remind you, but the idea is that one thing that is a constitutional protection that we the people have is that if you are technically arrested or being charged with a crime, you can try to challenge that the criminal statute is unconstitutional. And we're going to talk about a little bit of that. But so the claim can be that the statute is unconstitutional on its face, is unconstitutional as applied, or both. And so a very brief understanding to help explain this to you is that an unconstitutional on its face law is that at the surface level, as you read through it, as you look at it, clearly it is not what it's supposed to be. Like, you look at it and you go, yeah, that's definitely not constitutional. That's a problem. So on its face, it looks like you can't use it. And so you're like, yeah, that's not right. Unconstitutional as applied means that it's written correctly, but the circumstances around it, how it's used, the way that that law is being applied to your particular case is misunderstanding, misrepresenting, or completely off the wall. So the idea that it can be unconstitutional on its face is it's written bad. Unconstitutional as applied is it's written well, but they're not following it the way it's supposed to be. Or it can be both. It can be poorly worded and it can be performed in the wrong way. So that is the first specific constitutional protection that is available, that is what we as the people have. The other one is a procedural constitutional protection. And this is where we get down to the ever classic, you have the right to a trial of your peers. There's a lot of particular pieces with the actual constitutional protection for procedure. So the book briefly talks about defendant can protest an unconstitutional procedure that occurs during prosecution. It could be arrest, interrogation, search, filing of charges, trial, appeal. If you are not getting a fair treatment, you can fight back and say that you're constitutional, you were procedurally unconstitutionally applied. And so then you can go, okay, this is why. And so defendant can make a motion to dismiss the charges, suppress evidence, or declare a mistrial. These are all reverse conviction. Like, there's a lot of options here. But the idea is that the procedural is something in the process wasn't right. Whereas the general constitutionality of a criminal statute, law, ordinance, whatever, is that it is either worded wrong or is applied wrong. I hope that makes sense. If not, please let me know. So this chapter has a lot of really good examples, and I do want to talk a little bit about this example because it really is good, and it comes back as we talk about some things. So when we talk about constitutional protections, so in our textbook, our example is Bill is on trial for obstructing a public sidewalk. He was arrested for standing in front of a restaurant's entrance with a sign stating, "Will eat any and all leftovers." The city ordinance Bill violated makes it a misdemeanor to stand or sit on a public sidewalk with a sign. To save money, the judge presiding over Bill's trial declares that Bill will have a bench trial rather than a jury trial. Before we even look at the rest of this example piece, I'm hoping that your beginning criminal justice minds are like, wait, there's some things wrong with this. So in this example, Bill can constitutionally attack the city ordinance for violating his freedom of speech because it prohibits holding a sign. Notice, the city statute is that, or the city ordinance is that it's a misdemeanor to stand or sit on a public sidewalk with a sign. That is a form of expression. That is a form of speech. That would be a constitutional right that Bill has. So because of that, the ordinance is unconstitutional on its face and as applied to Bill. Now, the other piece to this is Bill can also constitutionally attack his bench trial because he has a right to a jury trial. Remember, a bench trial is when a judge is the jury as well. They're the only one that makes the decision. They hear the evidence and they put forward their verdict. Whereas a jury trial, they get a jury of their peers to hear the information, hear the evidence, and make that decision. So he could do this by making a motion to declare a mistrial, petitioning an appellate court to halt the trial, or appeal after a judgment is actually happened. So after a judgment of conviction. The point is, this particular case shows an issue with both types of constitutional protections that you can, as a citizen, use. Where you go, whoa, 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 whoa. You're violating my First Amendment right, and you are denying me my right to a trial of my peers. So it's important to talk about that and understand. And so we kind of talked about it already, but remember that judicial review is the primary power that the Supreme Court has. Why that? My brain went there. Judicial review is literally the chance to look over cases and make decisions on how a case going forward will look. Um, so we'll talk a little bit about that, but I just want to bring up the constitutional protections figure 3.1. This is going to come up a lot in this chapter in particular, and so I need to say this now. This text in particular was in the mid 2010s, so Roe v. Wade was still in effect. I know that it has been overturned by the Supreme Court that's currently sitting. It is a constant thing, so obviously as things happen, um, I'm hopeful that this will get turned again. I hope that Roe v. Wade will be understood as a constitutional right. But I just want to let you know, like, the textbook is written during a time where Roe v. Wade was covered, so we will be talking about that. But that's the most dated issue with this book, is that Roe v. Wade is still technically constitutional at this time, and it should be. Just want to emphasize that, and we'll talk about that in this class as well. So typically, a court balances the government's interest against an individual's interest, and that's really the whole point of a trial, specifically when we're talking about criminal court, and that's kind of what I want to get at. So we've talked very briefly, or I hope I did. If not, I'm sorry. The biggest difference between civil court and criminal court: civil court is between two individuals or two groups of individuals, whereas criminal court is the idea that an individual is affecting society as a whole. So the government acts in place of that and attaches onto that. So how that works is that in a court case, the court itself, whether it be the judge and jury or the judge or legal experts, whatever it may be, the idea is that they weigh the government's interests in regulating whatever conduct versus the individual's right. So it's why we have things like, there's anti-public nudity laws in a lot of places, like balancing your individual interest and right to walk around completely naked versus the idea that the government has the right to say, well, it is decency for the vast majority of people to not have to see other individuals' private parts on display. It's one weirdly specific example, but you'll understand why I bring it up. But so this is where this argument comes down to, and this is where the constitutionality of certain rules comes in place, and why judicial review is important. So the big piece to know is that if a constitutional right is fundamental, like you have access to medical provisions that are life-saving, you have autonomy over your body. Notice I'm wording these very carefully. The idea is that if they are fundamental, the court uses a strict scrutiny as they look at and apply their judicial review. The idea is that strict scrutiny means that they are looking at it very closely, and they are trying to determine if it is constitutional or not. And so, for the most part, this is it's in the text, but it's a cool thing. So, the government has to, in a criminal suit, the government is not the defendant, they are the prosecution. So, the government has to prove that whatever statute is being challenged is supported by compelling government interests. And so by that, they use a rational basis test. The rational basis test allows you to understand, it's essentially a chance to balance what is and what is not allowed. And I really want to jump into the next thing. Sorry. So one of the things that we have to remember when I say rational basis test as well as the strict scrutiny, most constitutional rights are considered fundamental. The right of free speech, the right to bear arms, the right to freedom of religion, to gather, like these are considered fundamental. So they are always going to be strict scrutiny. So it is part of the reason why there's always difficulty in free speech cases. And I really want to emphasize that. Freedom of expression and freedom of speech cases are very, very difficult when they look at it because it is very strict. It is very what constitutes speech, what constitutes the personal freedom being impeded on versus the general good. Again, one of the cases that you're going to be looking at for the case study reports is 100% this case. So if you're paying attention to the notes, you're paying attention to the lecture, and you're going to do your case study response, hint, hint, it is 100% a First Amendment issue, a freedom of expression issue. And so it's very strict scrutiny. Whether it was done correctly or not is a different case. Um, but the rational basis test just very, very, very basically goes, okay, here are the list of what are legitimate government interests of this case. Are they more important? If they are, then yeah. It's a lower requirement. It does not have to be nearly as strict, is really what it comes down to. It's the much like a rational person would make that decision, that kind of idea. So, example of strict scrutiny, I gave an example as well without saying it, but so going back to the Bill example, who was arrested essentially for standing and holding a sign. U.S. Supreme Court has held that freedom of speech is a fundamental right. Thus, the court reviewing the ordinance in Bill's case will hold the ordinance presumptively invalid unless the government can demonstrate a compelling interest in enacting it and that it used the least restrictive means possible. The problem is that the ordinance is broadly written to include all signs, and preventing individuals from holding signs does not serve a compelling government interest. So, this difficult standard will probably result in the court holding the ordinance unconstitutional. Boom, done. All right. These are two things that we talked about briefly in Intro to Criminal Justice. Spent a decent amount of time in the notes talking about it, but so the legislative branch, there do have prohibited powers. So the Constitution's prohibition against two important things, and that is the Bill of Attainder and ex post facto laws. And these are in the Constitution. So Article 1, subsection 9, Clause 3 states, in a pertinent part, no bill of attainder or ex post facto law shall be passed. The prohibition on bill of attainder and ex post facto laws is extended to the states in Article 1, subsection 10, Clause 1, no state shall pass any bill of attainder ex post facto law. So, what the heck does that mean? So, bill of attainders really are just you're punishing an individual without a trial. That's the whole idea. A bill of attainder is essentially waiving an entire court system. It's just saying, yeah, this person doesn't get a chance to defend their case. It's just whatever decision happens. That is an issue because, as you know, it is a constitutional right that you are allowed to have a trial by your peers. Now, does this mean that a bill of attainder does not happen? No. The idea is that it's there so that everyone has a full and fair trial. So obviously there are some very rare examples, and they tend to be. I can't even think of a good example off the top of my head, but it's important to know that this is something that is seen as unconstitutional, and which is why there's a protection against it. So their example that they give here, I feel is a dated one because it's kind of a ridiculous thing, but we can see something kind of similar here in our modern society, and we'll touch on it very briefly. But Brienne is a member of the Communist Party. She applies for a job as a teacher and is refused based on this statute. Members of any subversive group, including the Communist Party, cannot hold public office nor teach for a public institution. Technically, Brienne could attack the statute as a bill of attainder. Its provisions targeting members of the Communist Party or any other subversive group punish by eliminating career opportunities. So, technically speaking, in this example, yes. Just because she is a member of the Communist Party, does that mean that she's going to be spreading communist propaganda in the classroom? Not necessarily. But the fact that she is denied a chance from teaching at a public institution based off of her association, that would be a bill of attainder. So yes, she would have a case to make on it. We see this happen in a different way. It's not necessarily... There's a lot of issues that are currently going on in the world. Technically speaking, there are local municipalities, not here in Pennsylvania, that push forward ideas of, if an individual is gay, they can't work somewhere, or those which historically have existed just about everywhere, but now are harder to find, those would fall under that. That is a subversive group that is not allowed to do that. Or rather, they are a marginalized group that is not allowed to participate. And that's something that you are punishing them based off of something that has nothing to do with a constitutional right. But again, that's a very particular piece, and I want to emphasize that Bill of Attainder is harder to fight and obtain, but it does happen. Ex post facto, in case you don't know Latin or root words, which are Latin roots anyway, ex post facto literally means after the fact. So ex post facto laws are retroactive punishments. Let me say that again. Ex post facto laws are retroactive punishments. And so there's really three breakdowns to this. It is one, that you punish a behavior before the law was in effect. So someone is already in trouble for it. Wait, that's the second one. You essentially, someone committed a crime before the law was existed. And then the law comes into place. And then now you charge them for that crime that they committed before it was illegal. You can't do that. That's not how that works. Number two is you increase a punishment after the crime has been committed. So they committed a crime, and let's say the sentence was 3 years, and then all of a sudden they changed the law, and so now it's 10 years. You can't change that person's sentence from 3 years to 10 years. That is unconstitutional. You cannot punish them after the fact. Yeah, it changed, but you can't change the sentence that you already gave someone, not without another trial. And then the third one is an increased possibility of conviction after a crime is committed. And so this kind of goes back to that first example where you committed a crime maybe before that particular law was in place, and now all of a sudden you go around and you arrest people who committed that crime before it was illegal. The idea here, though, is that because it's now illegal, you can get more people in trouble, or in worse trouble, or whatever it may be. And it's like, you can't do that. So really, no matter how you break it down, remember that ex post facto means after the fact. So it's always some kind of punishment after something has already happened. And so it's not supposed to be allowed. And that's why they, in particular, the Constitution fights this down and says that this is unconstitutional. So, uh, minor trigger warning: the example that they use for punishing behavior retroactively in the chapter, as well as we'll talk a little bit about it just in general. We are going to be talking about murder as well as technically abortion a little bit. But anyway, so in this particular example of punishing behavior retroactively, a state murder statute defines murder as the killing of a human being born alive. If the state legislature amends the statute to include the killing of a fetus, with the exception of abortion, the amendment extends the application of the statute to all criminal fetus killings that occurred before the statute has changed. If this happens, that's not okay. If the state attempts to include this language punishes defendants for behavior that was legal when committed. If they attempt to do that, the court strikes it down, saying that it violates that because it is an ex post facto law. So they go back and say, well, when you kill a human being born alive, well, technically if you kill a fetus, that they're not born alive, so we got to change that, and that all of a sudden makes it a little messy. This is why talking about abortion, women's reproductive rights, and Roe v. Wade is important. Ex post facto kind of puts this in a little bit of a idea here. So, following with that example, they talk about this as well. In the preceding example about amending the murder statute, the state also amends the statute to increase the penalty for murder to the death penalty. So let's say it was life in prison. You cannot take a prisoner who is life in prison and then give them the death penalty. It doesn't work that way. That would be against their rights. Even though they committed a crime, they were found guilty, they still have their constitutional rights. You can't take that away. So you can't say, well, now it's the death penalty, so you're going to die. You can't do that. And then the other one is increasing possibility of conviction. This one really comes down to statutes of limitations. If you're not familiar with the statute of limitation, it is most laws and illegal actions have a statute of limitations, a certain amount of time from when the crime occurred till a certain end date that someone can be convicted of that particular crime. It varies by crime to crime, but the idea is that technically speaking, if the statute of limitation was 20 years and a new law increases it to 50 years, that space between the 20 and 50 years, you can't prosecute those people because they were outside of that. It's a weird one in particular, especially because typically with statute of limitations, the ones you hear most often are murder and sexual assault. And so it gets difficult to talk about why it's covered and why it's not allowed to be changed, because that kind of piece fits in there. The other big thing with ex post facto laws, the only time that they can be good is when they actually benefit. So reducing the sentencing time or things like that, they're seen as constitutional because they're there to help the individual. And yeah, just in general, ex post facto laws, the ex post facto law protection of the Constitution only covers criminal law, not civil law. So sorry, fees and taxes, not covered, unfortunately, which is a pain in my butt. All right. So that was the first part of the chapter. Like, it was a lot of review, but it was a lot of more detail stuff. And so some of this is going to be a lot quicker now. So we need to talk about due process and equal protection clauses. So due process, the Bill of Rights contains most of our protections for both criminal defendants and the everyday citizen. So what is due process? And I'm sure as I say that, everyone's like, it's obvious what due process is. So Yes, due process is essentially the balance of law. It is all laws have to be followed in a particular way for fairness. So no person shall be deprived of life, liberty, or property without due process of law is the official statement. The idea here is that no matter what happens, you are given access to the same opportunities as anyone else going through the system. The idea is that you are not allowed to be discriminated against. Just going to leave that there for a moment. All right. So there are two types of due processes. Like everything else, it's substantive due process and procedural due process. I'm sure at this point you can figure out what procedural due process is. It's, you are protected from being criminally punished without notice and an opportunity to be heard, aka you can't be just punished without having a case without having a trial. And then substantive due process. This is you are protected from unreasonable loss of substantial rights like the right to speak freely, the right to privacy, which we're going to talk about in a little bit. So you're not denied your life, which is capital punishment, liberty, which is incarceration, or property forfeiture. My gosh, I struggle with that word. It can't be arbitrary. And arbitrary means at random, like you aren't really making a decision based off of facts. And so this is where I get to say I am an English teacher as well, and void for vagueness is essentially the first English paper that you write in English Comp 1. It is the argument of definition. And this is important, and it's why we teach it there, and it's relevant to criminal justice. So anyone that says, why do I have to take English College Comp 1 if I'm in criminal justice? This is why. Void for vagueness. And this is also why, in case you haven't noticed, I've mentioned in all of my assignment sheets for this class that spelling and grammar counts. Because in criminal justice, specifically in criminal law, if your interest is going into the law, whether it be at the early points of a police officer or later points as a probation officer or a lawyer or a judge or whatever it may be, you have to be able to write effectively. This is a key skill. Because void for vagueness challenges the wording of a statute or a law under the due process clause. If the wording is unclear, if when reading it, someone could say, I don't understand what this actually is being made, what the point is, you can argue that in a court of law and get either the statute put as unconstitutional and get thrown out or get revised. You need to be able to effectively speak. And if you want to be a lawyer, you really need to be able to effectively speak, and you need to know how to write. So, a statute can be claimed void for vagueness if it's unclear. The other issue in general with vagueness is overbreadth, or the idea is that it's overbroad. To use a terrible analogy, that you cast a wide net to try to cover every possible. Well, that's an issue because by trying to hit every possible thing, you're too broad. So this example that they give, the statute that is void of vagueness, and I would argue is also overbroad, is state legislature enacts a statute that criminalizes inappropriate attire on public beaches. Well, what is inappropriate attire? If I asked every one of you privately, what is inappropriate attire? I could guarantee I'll probably hear some similar pieces, but they're not going to be exact. In the example, Larry, a law enforcement officer, arrests Kathy for wearing a two-piece bathing suit at the beach because in his belief, women should wear one-piece bathing suits. 2 days later, Bert arrests Sarah for wearing a one-piece suit because in his belief, women should not be seen in public in bathing suits. There's an issue here. Both women can be arrested for inappropriate attire on public beaches. Should either one of them be arrested for inappropriate attire? I would definitely argue No. This is the issue. This is why void for vagueness and saying inappropriate attire, that's too broad. You need to be specific, guided, and clear. So anyway, yeah, I don't want to dive into this simply because nude individuals who are under the age of 18, that is a big issue. We don't need to dive into that. But of course, there's the ever classic issue of your naked baby pictures. I guarantee your parents possibly at some point have some. I have recently received from my mother and my aunt 5 of my baby pictures where I am bare bottomed. So technically, this statute would be totally bad, but at the same time, they're my adorable, cute little baby butt. Like, who cares? But there's issues with that, and we don't need to dive into it because it is a very uncomfortable conversation. But the idea here is that when you try to cover too many things and when you're vague in your wording, it's very easy to fight against it and say that it's unconstitutional. Focused, clear ideas. And so the other side of this, so that was due process. Equal protection clause. The 14th Amendment states, nor shall any state deny to any person within its jurisdiction the equal protections of the law. Very basic. Equal protection clause, really, it prevents state governments from enacting criminal laws that discriminate in an unreasonable and unjust manner. Short form, a state cannot make a law that discriminates against a group of people that do have rights at the federal level. AKA, in today's world, you cannot have Alabama make a law saying that any individual person of color cannot own property. You can't do that. Equal protection clause. They are allowed the same rights as every person of the United States. The bigger issue is that it doesn't always happen. Because if you remember, I do mention criminal justice and criminal law itself is very gray. There's not black and white. It's a lot of gray. A lot of, even things that you think should be very black and white, like don't be racist, don't be homophobic, don't be this. I agree with you 100%. On a human level, we should not. But in the criminal justice system, it should be black and white in that way. It's not. So, anyway, now let's talk about a couple constitutional pieces. I told you we'd get to it. Let's talk about the freedom of speech. So, I'm just going to go right out there and say, what exactly is freedom of speech? And better yet, define speech. Because that's the piece that has taken some kind of effect in decisions. So, really, the Supreme Court eventually came up with the idea that technically just about any form of expression can be considered speech. So whether it's actual talking or written words, it can be pictures, photos, videos, songs, art pieces, dressing a certain way, like any kind of expressive art or expressive action can be seen as speech. This leads to some interesting debates. So before we dive into that one, I do want to just real briefly say that there are exceptions to the First Amendment's protection of freedom of speech, in case you didn't know about that. So there's a lot of particular sub ideas. For the sake of this book and as pretty much criminal law in general, there are 4 main exceptions to the freedom of speech, and that's fighting words, incitement to riot, hate crimes, and obscenity. Fighting words and incitement to riot. I wonder. January 6th. Anyway, that's my own little thing. It really is an example of speech that is not covered, and we'll talk about that why. So, first one, we're just going to go through that order. Fighting words. First Amendment protects peaceful speech and assembly. It's your right to peacefully protest. If the speech creates a clear and present danger to the public, it's allowed to be regulated. The entire idea is that if the language being used is intent to cause a fight, or we'll talk about inciting a riot, then it is no longer peaceful words and it is not covered technically. The big piece that gets it to that point is that, is there an immediate breach to the peace, an immediate concern for the general public? If it's just, we're going to get together in 5 weeks from now and that's not immediate. It's imminent, but it's not immediate. So, incitement to riot, very similar to fighting words, but the idea is that it's presenting clear and present danger. Because if you are trying to start a riot, that is showing you that we've got an issue. We are trying to cause chaos. And this is where I get to say, January 6th, the speeches and stuff that was going on, whether you're Democratic or Republican, you like or hate former President Donald Trump, it doesn't matter. These are the facts. The speeches that were going on and the conversations around the stealing of the election, that conversation was meant to incite a riot. It was take back the Capitol, take back the win. And it's like that is clearly, that is something that is not covered under free speech. That is looking for violence. That could be construed as fighting words. It is incitement to riot. Like, no way around that. That's all I'm going to say about that. So our book does have some examples of this, of unconstitutional fighting words, unconstitutional incitement to riot statutes. It's important to read through these because they are interesting. Georgia being Georgia. We have the KKK being the KKK, and we're going to talk about hate crimes. So for the most part, hate crimes, how do I want to say this? Hate crime statutes that criminalize speech. So if we're looking for a particular constitutional exception for this, if the hate crime, the hate speech, if it's particularly, if the clear and present danger is there, or is seemingly there, particularly to either cause the violence or meant to intimidate, yes. If it's meant to criminalize the exact content of the speech, it's not. So it's a weird, that's why I'm like, hate crimes, I hate talking about this because it's difficult. You can't regulate the words someone says, but you can regulate the reason for saying them. So that's really what this idea, this exception is. And again, there's an example here. They also talk about cross burning because, yeah, that's an issue. So, another exception to issues with free speech is obscenity. And so I'm just going to generally put this out there. What does it mean to be obscene? And so, in general, thanks to Miller versus California, 73, the U.S. Supreme Court said that there's a 3-part test to determine if speech is obscene. And generally, that goes down to 1, if the average person applying contemporary community standards would find the work, when taken as a whole, appeals to the prurient interest in sex, aka this inappropriate type of interest in sex. Number 2, it depicts sexual conduct specifically defined by the applicable state law in a patently offensive way, and it lacks serious literary, artistic, political, or scientific value. This is why when people take this part and they're like, it shouldn't be in schools, it shouldn't be this, taken as a whole, this is the part why oftentimes it doesn't go anywhere. You can't limit speech or obscenity if the whole thing that has that one part is not bad. All right, so examples of speech that is not obscene. There's a film, Carnal Knowledge, and this is a conversation about it, but that's not the one I want to focus on. This is the one that I want to focus on because this is going to be your first case study response for this week. Nude dancing. Statutes that regulate nude dancing have also been attacked under the First Amendment. Although the U.S. Supreme Court has ruled that nude dancing is constitutionally protected expression, it has also upheld reasonable restrictions on nudity, such as requirements that nude dancers wear pasties and a G-string. The City of Erie et al. Versus Pabst AM. You're going to be interested, or rather, I was horrified when I realized. I was like, please don't be this. Please don't be this. Yep, it is our City of Erie. So very briefly, as a little heads up, this particular case is the City of Erie versus Pabst AM, which is the parent company that owned Candyland when it was in Erie, and it's now Candy's out in, oh gosh, not Summit. It's all the way past Fort LaBeouf area. I'm trying to think of the area, but this is the famous Candy's case that is an Erie legend. So yeah, this is a legitimate thing that our textbook even talks about it, and I'm like, oh God, we're in a textbook, in a legal textbook about criminal law. So yeah, that's going to be one of the ones we look at because it's our own city and it's relevant. It also very much deals with First Amendment issues. Hint, hint, this is going to be stuff that's important to your response. But yeah, please take that with a grain of salt. Consider that. And we're moving on. Okay. The right to privacy. Probably my favorite fact to tell people. The Constitution does not explicitly state anywhere that you have the right to privacy. Not anywhere. And if you're like, wait, what about nowhere in the Constitution does it officially say that every citizen has the right to privacy? It comes down to, it's an amalgamation. So the U.S. Supreme Court set a precedent, and then eventually it kind of created a general, based off of modern interpretations of the Constitution, a right to privacy. And it comes from the 1st, 3rd, 4th, 5th, 9th, and 14th Amendments. So first, protects the right to speak freely, assemble peacefully, and worship according to your individual choice. Third, prohibits government from forcing individuals to quarter, house, or feed soldiers, aka you don't have to open your doors to someone else. Fourth Amendment prevents government from unreasonably searching or seizing an individual's property or themselves. Fifth and 14th are due process of the law before a government can deprive an individual of life, liberty, or property. And ninth states that rights not explicitly set forth in the Constitution may still exist, and that's the piece. The Ninth Amendment is that important one, that there are constitutional rights that exist that are not explicitly set in the Constitution. It's when we are writing this, we know that there's other things that we just don't understand yet. Boom. When you take that all together, it's clear that the Constitution was meant to help be a barrier between over-restrictive governments like a monarchy from affecting the people. And so the privacy guarantees the right, and it hasn't aged well because of our Supreme Court. The right to privacy guarantees the right to use birth control, the right to an abortion, and the right to participate in consensual sexual relations. Obviously, the right to an abortion is Roe v. Wade. We're not going to really talk much about it, just simply because it is a currently developing story. So, the right to use birth control, I want to emphasize this case in particular. If you were going to ever see an example of a case show up on a test and be like, what is its importance? This is the case to know. Griswold versus Connecticut, 1965. This particular case found that there was a constitutional right to have access to birth control. The idea was that a married couple wanted to have birth control, but according to the Connecticut statute at the time, it was criminalized to use birth control. The court was like, you can't determine what people do in the privacy of their marital bedroom. They are married. They are two private citizens. You can't tell them what they can and can't do in their bedroom. And so it found that you have the right to birth control. Planned Parenthood employees could not be in trouble for prescribing birth control as an accessory to this state statute based off of this private decision. The Griswold case is the whole reason that female bodily autonomy, anything related to intimacy, so that's a sexual relationship. This is also, without Griswold versus Connecticut, there really wouldn't be a conversation about gay rights, because the privacy of your own bedroom comes back to play, and we'll talk about that in just a minute. Because Lawrence versus Texas 2003, which is one of the other ones that we're going to talk about, is all about the right to consensual sex, and it was a homosexual couple. We'll talk about that in a minute. So right to abortion is Roe v. Wade, 1973. The whole thing was that, the court held everyone has the right to legal abortion through the first trimester of pregnancy. It has always been a touchy area because there are a lot of people that have very strong opinions and thoughts on whether it's morally right to have an abortion. And reminder that the people that make the laws and the people that do these things are people like you and me. They have opinions, they have belief structures, and it just so happened that the majority of the Supreme Court at the time believed that abortion was wrong and that the federal government should not be involved in saying, yes, it is allowed anywhere. Let the states decide it. Whether it's right or wrong, I would say it's wrong, because I would definitely argue it is a constitutional right. This is an issue of that. And that's why I said we're not going to talk too much about it, because this is an ongoing issue. If you want to talk about Roe v. Wade, and maybe if you haven't started and you're thinking, what could I do my supposed case on? Something in relation to the right to an abortion and Roe v. Wade might be interesting, especially in a post-Roe v. Wade world. All right. So the right to consensual sexual relationships. This is, again, without Griswold versus Connecticut, without Roe v. Wade, these things would not be. So there's been several issues. So text gives us Bowers versus Hardwick in 1986. They upheld a Georgia statute that made it a crime to engage in consensual sodomy, aka you can't have anal sex. It clearly is aimed at gay individuals, but it's because the court stated that there is no fundamental right to exchange in sodomy, and that the history of protecting marriage and family relationships should not be extended in this fashion. Blah, 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 blah. The usual very anti-gay rhetoric. Lawrence versus Texas, 2003. A Texas statute criminalized homosexual sodomy. The issue was it applied to two men who were discovered engaging in sex in their bedroom during a law enforcement search of weapons. They weren't being arrested for sodomy. They were being searched for weapons. And the officers just happened to notice that, oh, these two men are having sex. Uh-oh, that's not allowed. So then they were in trouble for that as well. And they fought it. And the court eventually did held that intimate choices are a form of liberty protected by the due process, whether or not the consenting individuals are married. It said, well, you know what? Sorry. What they do in the privacy of their own home, going back to Griswold versus Connecticut, what people do in their own home at their own time, as long as it's not directly affecting society at large, aka planning a murder or bomb or whatever it may be, they're allowed to do it. And so this is why it's important to understand the right to privacy. While it doesn't explicitly exist, it is there. And it's always a constant struggle. It's why members of the LGBTQIA plus community fight for equal rights. It's why people of different color and different backgrounds and religions constantly fight for equal rights. Because as long as they're a citizen of the United States, they are told that they are protected in the Constitution. And there are people that will fight them on that. And so they go right back to this and say, well, look, these are examples of how it changes. You have the right to privacy. You have the right to be who you are. Boom. All right. Sorry. As you can tell, I get really passionate about that particular piece. It's relevant to me. The right to bear arms is the Second Amendment, and this is going to be the briefest section I can even talk about. The overall general idea of the right to bear arms is problematic at a very base level. Not that the right to bear arms is wrong, it's just that the Second Amendment provides, quote, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The Second Amendment says that we need to be able to have a well-regulated militia being necessary to the security of our free state. So that means that the right of the people to keep and bear arms shall not be taken away. No issue there. The issue is when we talk about the right of the people to keep and bear arms. The arms that are being talked about in the historic sense are very different than what is currently available today. Obviously, District of Columbia, so DC versus Heller, 2008, is a court case that tries to bridge the gap between a traditional reading of the Constitution versus a modern interpretation of the Constitution, and it's where it tried to ban certain levels and put restrictions on firearms. It did succeed in getting some better regulations on firearms, but it did not do what they wanted to, which was ban handguns like completely from being in like a public space. And when it was at home, it had to be fully discharged and essentially disassembled. Clearly, you can't make that because that's digging into people's privacy. So that's why it didn't really go anywhere. But the example that our book gives is really good. Public middle school janitor, occasionally with permission from the principal, the janitor stays overnight. Just if he has to be there late, and he wants to keep his handgun in the outbuilding for protection because he's there late at night alone. But if the state has a statute prohibiting handguns, he can't have it. But technically he has the right to have a handgun to protect his home or for self-defense. But since he's not at home, it doesn't qualify, and it gets really weird. And this is why I just say the right to bear arms is problematic. There are too many variables when we talk about weaponry. I would extend this to knives, blades, swords, any kind of weaponry. The right to own a weapon for defense, that's not an issue. The issue is the 18 million subpoints of what does it mean to own a weapon? How is the weapon stored? You can't regulate these things. It's a very problematic constitutional right. That's all I'm going to say. I'm not saying we need to repeal or change it. I'm just saying we need to understand that it's generalized phrasing and unclear interpretations lead to issues. All right. And so our last section of this chapter is excessive punishment. Sorry, it's already going on a little bit longer than I expected it to, but we've had a lot to talk about. So excessive punishment, there are really three reasons or three issues of some kind of excessiveness to this. So very, very briefly, the Eighth Amendment states, excessive bail should not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. That's the one everyone knows, is the no cruel or unusual punishment. That's the part they always focus on. Like, okay, fair enough. The idea here is that you cannot be excessive in how you go about punishing an individual, whether they're found guilty or not. So, the first point is cruel punishment. And so, in general, the government cannot inflict cruel or barbaric punishments. This is where things get interesting because this is where the death penalty comes in. So, the big key word is inhumane. Whether we're talking cruel, barbaric, the idea is that inhumane. Cases that talk about excessive punishment and they talk about cruel punishments, the word inhumane. It is not right to inflict this on a human being or on any living being. The idea of capital punishment, it has been around for a very, 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 very long time. We have it. PA is one of the states that does have the death penalty. There are 16 states that don't have the death penalty. They've outlawed it. It is a debatable topic. I'll be straightforward with you. As a teacher, I am supposed to not share my opinion. I'm supposed to share the facts, and I am sharing the facts. Me personally, I do not agree with the death penalty. You can feel how you want, but I do not believe that it's our right to take the life of another person. It's because me personally, I like to believe that there's number one, redemption, and number two, that not everyone that's incarcerated and put on death row did actually commit that crime. So I'm not big on the death penalty itself. I'm more for life imprisonment without parole. Anyway, that is my personal statement. But what I'm trying to say here, and why I say that's my opinion, I understand where the concept of the death penalty comes from. I understand its purpose. I'm saying that I just personally don't agree with it, but I will gladly talk about it and teach it and give it its fair due. So, the biggest part with capital punishment, with the death penalty, where people call the inhumane part, is how the death penalty is administered. It's the method in which. So, I think Texas is the only state anymore that allows shooting. There might be another one. I thought it was only Texas now, but so you could request execution by firing squad. So that seems inhumane, being shot to death. Uh, Death by hanging, that is a very brutal way to go. I'm pretty sure I don't think anywhere still does hanging, because there's a lot of issues with hanging. Electrocution, gas chamber, lethal injection. Obviously, the one that most people are familiar with nowadays is lethal injection. That is the one that's most commonly used in the States. It is technically the most humane way of killing an individual, because the specific concoction of drugs is meant to numb any pain and they just kind of go. Obviously, if it's not administered correctly or they don't have the right dosage, it causes issues. And so there are a lot of cases and arguments about it being inhumane. But the point is, like, across the board, the method of capital punishment, the method of the death penalty, is the argument that's made for excessive punishment in this idea. Um, so the other of the number two of the three main issues with excessive punishment is disproportionate punishment. This is the idea that it's too severe. So you do a crime and you're punished way more than what you should be for that crime. That's pretty straightforward. But one thing that the book wants to talk about, and it is important, is three strike statutes. So if you're not sure what the three strikes statutes are, there are several states that have three strike laws. I'm sure you've probably heard that before. Uh, I know California is. I believe Florida is, because it's always Florida. But the idea is that when you've committed three felonies, that third one you're out. So you've done one felony, you get some jail time. You commit another felony, you get more jail time. Third one, you're on death row, you're done. The issue that typically comes with three strike laws, and that's why I want to say this in particular, the three strike laws deal with felony charges. But the question is, does any felony charge count, or is it a particular felony charge, like a violent felony charge? So the examples that the book gives are assault, sexual assault, murder, kidnapping. Like, clearly, if someone has done that three times, I think we can agree on that one, that probably the punishment is fair. But if one of them was arson that didn't take the life of anyone, like, I don't know that that should count towards that three strikes, especially if it's the third one. Like, imagine you kidnapped someone, you got in trouble. Okay, you've reformed yourself. You technically did some terrible things and you were convicted of a second crime. All right, one more felony and you are in jail. And you get the dumbest felony charge ever. Now you're stuck with life in prison or death row. Is that necessarily fair? There's issues with that. So technically, like I said, the big issue with three strike laws is that it needs to be specified in each location. So I believe California is the strictest one. Like, it's very specific which felonies are uh, processed under the three strikes law. I'd have to double check on that. And then the last of the three excessive punishments is invalid under the right to a jury. So what this breaks down to, it's sentencing enhancement by judges. That's really what's going on. So when you consider that a case your right to a trial by jury. You are given the right to present evidence to the jury. The jury makes a decision, they put forward recommendations, and then you are sentenced. The issue here is that, let's say that you put all forward the evidence, the jury has made a decision, and then the judge, just on a whim, whether because they're upset that day or maybe because they think differently about you, they change the sentence to make it worse. That's not okay. That is called excessive punishment. That is specifically sentencing enhancement by a judge. And so that would be an issue. So obviously, there's plenty of examples throughout this. I urge you to read through the rest of this. I just wanted to make sure that we touched on some of the key points. The last thing that I want to talk about, and that's very briefly, is our case of interest. If you stuck around this long, your number 2 case study for this week is Robinson versus California. This is all about cruel and unusual punishment. In particular, it talks about drug addiction. This, I think, is a fantastic example, even though it's older. I think it's a really good case that we should be thinking about, especially how we apply these things still today. All right, that's all I have for you. Sorry that it took a little bit longer. There was a lot to talk about this week. Starting next week, I'll probably have written notes as well. So who knows? Thank you very much for sticking around, and have a wonderful day, night, morning, third shift, fourth meal, whatever it may be. See you all soon.